What's up everyone, it's the Law School Lumberjack, and today I'm extremely excited because I'm introducing a new series, the Property Law 101 Fee is Not Simple series. So this series is going to go through fee simple interest, estates, some real property issues, and some case briefs associated with these topics. So without further ado, today we're going to be talking about fee simple interest and the types of conditions and restrictions that can be placed on the transfer. In our next video, we're going to be discussing life estates and the types of restrictions that can be associated with that, as well as their application on law school exams. Dealing with fee simple interest, there's kind of two things in property law in first year that you're going to deal with. You're going to deal with estates and fee simple transfers with respect to estates, as well as real property. To start out, we're going to deal with estates, and then in subsequent videos, we will deal with real property interests. So understanding today's topic of fee simple transfers will really help you understand the case law surrounding estates, which you will see in your law school courses. One case, for example, which involves these topics that we'll touch on today is the City of Caroline and Roper, which I'll be briefing in a subsequent video. So without further ado, let's start with the basics. So what is a fee simple interest and what does it entail? So when you have a fee simple interest in real property, you have a right to all of the bundles of rights associated with that property forever, into perpetuity. So you're probably wondering, okay, I can't live into perpetuity, so what happens to those rights? So if you have a fee simple interest and you pass away, that fee simple interest transfers into your estate and presumably to your descendants, spouses, etc. So as a side note, it's really important to remember that somewhat in the estates section, but especially in the real property section, that when it comes to fee simple interest and any interest whatsoever, a person who's receiving those interests from someone can only receive what that person has. And that Latin maxim is called nemo dat quod non habet, or you cannot give what you don't have. So we're not going to be touching on that too much in this video, but in the real property section, that's going to be a major topic, and it's extremely important with transfers of real property, and fee simple interests. So there are three types of conditions or restrictions that can be placed on a fee simple interest. The first is a condition precedent, the second is a fee simple determinable, and the third is a fee simple with a condition subsequent. And so when a condition is placed on a fee simple interest or a transfer of a fee simple interest, we call that a defeasible estate. So if you ever hear someone say a defeasible estate, it essentially means a transfer in fee simple that is subject to a condition. So let's go through the most simple one, which is a condition precedent. A condition precedent is a condition that must be satisfied before the transfer in fee simple can take place. If a condition precedent is not satisfied, then the transfer in fee simple does not happen. However, once the condition precedent is satisfied, the transfer in fee simple takes place. So to make this very clear, what I'm going to do in this series is use three characters and give lots of examples. So these three characters I'm going to have are called Abe, Bob, and Claire. For the sake of the examples, Abe and Claire are married, they're husband and wife, and Bob is Abe's brother. So let's use an example. So Abe wants to take care of Bob when he passes away, but he also wants to make sure that Bob doesn't get a windfall over Claire. So Abe, once he dies, transfers his interest in land to Bob if Bob survives Claire. So the words might be, I, Abe, transfer my property, let's say Abe lives in Toronto, to Bob if Bob survives Claire. So let's really unpack this. So if Bob lives longer than Claire or survives Claire, then he receives the fee simple interest in the Toronto property. However, if Claire lives longer than Bob, then the transfer in fee simple does not take place. That is what a condition precedent does. It essentially is a triggering event that must occur before the transfer in fee simple takes place. So now let's move on to the second type of condition that can be placed on a fee simple interest or a fee simple transfer, which is a fee simple determinable. A fee simple determinable is a transfer in fee simple which terminates automatically upon the occurrence or non-occurrence of an event. So in essence, a fee simple determinable is a restriction that is put on the transfer of land that once that restriction is satisfied or is breached, then the land transfers automatically, usually back to the grantor. So let's use an example to make it clear. So if Abe transfers his land to Bob, so long as Bob uses his land for a daycare, then the transfer in fee simple takes place, but if Bob ever ceases to use the land as a daycare, then it would transfer back to Abe, or in this case, Abe's estate, because Abe is deceased. So language denoting a fee simple determinable, and this is important for when you're writing law school exams, because sometimes the language is really important. So if you see words such as until or so long as, you should automatically be thinking this is probably a fee simple determinable. Now, I won't go into this in too much detail, but I know you can also give what's called a right of reverter, which is what the actual transfer back to the grantor is. You can give that right of reverter to a third party. So, for example, Abe could say, I transfer my land to Bob so long as he uses it as a daycare, and then to Claire. So if Bob ever stopped using the lands, the lands wouldn't revert back to Abe, it would revert back to Claire. And that's called an executory interest. I won't go too much into that, that's much more complex and in-depth, but if you hear your professor talk about that, that's what an executory interest is. Now, finally, we'll move on to a condition subsequent. So, a condition subsequent and a fee simple determinable sound really similar, and they look really similar, which causes a lot of confusion for people. But it's important to remember that there's two main differences between a condition subsequent and a fee simple determinable. Now, additionally, it's important to note that there are certain words that denote a condition subsequent. So words such as on the condition that or however if usually denote a condition subsequent. Now, the two main differences are firstly that a condition subsequent comes with what's called a right of reentry rather than what a fee simple determinable has, which is a right of reverter. So as you'll remember, a right of reverter automatically reverts back, usually to the grantor. With a condition subsequent, the right of reentry means that a party must take steps to actually re-enter the land. So as a result, they're usually going to have to get a court order to re-enter the lands, unless it's statutorily mandated that they can re-enter the lands, usually upon a certain notice period. Now, the other second important difference between a condition subsequent and a fee simple determinable is that a condition subsequent can be held to be void due to the rule against perpetuities. So with a fee simple determinable, usually the rule against perpetuities doesn't come into play, especially if the land reverts back to the grantor or his estate. However, with a condition subsequent, you always have to be thinking, is this subject to the rule against perpetuities, which it is, and then if it offends the rule against perpetuities, is it unenforceable? So I will note, as just kind of a side note, where you see condition subsequents happen a lot in your day-to-day life, which might help you kind of figure out how a condition subsequent works, is actually in leases. So your landlord, assuming that you rent from a landlord, your landlord gives you the leasehold interest in the land, right? Really on a condition subsequent that you'll follow the terms of the lease, right? So if you do not follow the terms of the lease, then the landlord can take steps to re-enter the lands and take the lands away from you, or take your leasehold interest back. So if you breach your lease because you're studying too hard with music blaring and as a result, you get some noise complaints, the land doesn't automatically, or the leasehold interest doesn't automatically revert back to your landlord. Your landlord has an election. He can either re-enter the lands by following the Residential Tenancy Act, or he can waive the breach and usually give you a warning, but he has to take steps to re-enter the lands. So those are the three main conditions you're going to see applied with a fee simple transfer, and that's a bit of a primer on fee simple interest. I hope this was really helpful. If it was, I'd really appreciate it if you could like this video and subscribe to the channel. I'll be posting quite a few videos with respect to property law. New life estate video will be coming out soon, so I hope that you check it out, and I hope these are helpful. Thank you very much. Take care.